All right, Subpart D, Part 190, Subpart D, proceed with the adoption rule scope. This part is described the general rule making proceed with the issue of the amendment of the real repeal of the pipeline safety program or regulation of the pipeline hazard material safety administrator of the Department of Transportation. 19303, delegation for the purpose of the subpart. The administrator meeting with the administrative pipeline hazard material safety administration his or her delegates. 19305, regulatory document information with the have the conference of the relevance of the administrator relating with the rulemaking, including the notice of the proposed rulemaking, the comments received in response to the notice of the petition rulemaking reconsideration, denial of the petition rulemaking reconsideration, record of additional rulemaking procedures, proceedings 19325 of the final regulation maintained the pipeline hazard material safety administration, 1200 New Jersey Avenue, Southeast Washington, D.C. 205900001 on public docket. The docket material may be accepted with regulations.gov. Public comments may also be submitted with regulations.gov. The comment submission must be identified with the docket number to be also examine the public document material of the office of the department docket of the operation facility of the M30 with the U.S. Department of Transportation West Building, first floor, room W12 140 1200 New Jersey Avenue, Southeast Washington, D.C. 20590. You may obtain the copy of it during the normal business excluding the federal holidays for a fee with the exemption of the material of the Administrator of the PHMSA determined should be withheld with the public disclosure under Title 5 U.S. Standard Code 552B or any other applicable statutory provision. 19307, the records record of the pipeline has material safety administration relating to the rulemaking to proceed with the available inspection provided in Section 552B with the Title 5 of the United States Code Part 17 of the regulation of the Office of Secretary of Transportation Part 7 of the Title 19309, where to file the petition extension for the time comment with the 19319 of the petition. The hearing submitted under 193.27 of the position rulemaking submitted with 193.31 position reconsideration submitted under 193.35 must be submitted with the Administrative Pipeline Hazardous Material Safety Administration, U.S. Department of Transportation, 1200 New Jersey Avenue, Southeast Washington, D.C. 205900001. 193.11 General, unless the administrator for the good cause of the finding with the notice of impracticably unnecessary for the contrary with the public interest and incorporated the finding brief statement of the reason for it in rule. Notice the proposed rulemaking is issued in the interest of the person invited with the particular participate in the rulemaking procedure with respect to the substantive rule. 193.13 Initiating rulemaking. The administrator initiated the rulemaking with his or her own motion without how doing so, the administrative discretion excludes the recommendation of the other agency of the United States under the other interest of the person, including any of the technology advisory bodies established in the statute for this purpose. 193.15 Contents of the proposed rulemaking. Each note of the proposed rulemaking published in the Federal Register unless the person subject to the name of the personal server with a copy of it. Notice whether published in the Federal Register personal server. They include the statement of the time, the place, the nature of the proposed rulemaking procedure, reference of the authority under which is issued, the description of the subject within the issue that involved the substance of the terms of the proposed rulemaking, the statement of the time within written comments must be submitted, a statement of how and what the extent of the interested person may participate in the proceeding. 193.17 the interest of the person participate in the rulemaking proceeding, the submitting of the comments of the writing containing with the information review of the augmented arguments in accordance with the instruction participation in the rulemaking document. The administrator may invite any of the interested persons to participate in the rulemaking proceedings described in 193.25. For the purpose of subpart, its interested person included the federal and state government agencies of any political subdivision of the state. 193.19 petition for the extension for the time of the comment. The petition for the extension for the time of the submit of the comments must be submitted to the PHMSA in accordance with 193.09 with receipt of the PHMSA not later than 10 days after the expiration date of the state of the notice of the filing of the petition does not automatically extend the time of the petitioner comments. Petitioner is granted only if the petitioner shows the good cause of the extension, if the extension is consistent with public interest, if any of the extension is granted to all the person is published for the Federal Register. 193.21 Concept of the written comments. All written comments must be in English. The interested person shall be submitted as part of the written comments material considered relevant to any of the statement of the fact incorporation material of the provided reference should be avoided. However, when necessary, such incorporated material must be identified with the document title page. 193.23 the consideration comments received the timely comments of the received the recommendation of the technically advisory body established with the statute for the purpose of reviewing the purpose of the rules concerned with the considered before the final action taken with the rulemaking proposal, like file comments and the considering for as so far as practical. 193.25 additional rulemaking procedure the administrator may initiate the further rulemaking procedure proceeding through the administrator find the necessary desirable. For example, the interested person may be invited to the oral argument that specifically in conference between the administrator and the administrative representative, the internal as the person in which the minutes of the conference are kept. They operate, but the informal hearing is presided over the official designated by the administrator. There was a transcript of the minutes and they were kept to participate in any other proceeding that ensure the informed administrative action and to protect the public interest. 193.27 the hearing the notice of proposed rulemaking does not provide for a hearing. Interested person may be petitioned for the administrator of the informal hearing of the petition must be received by the administrator no later than 20 days before the expiration of the time stated with the notice following the petition does not automatically result of the rescheduling of the hearing. The petition is granted but only if the petitioner shows the good cause of the hearing. If the petition hearing is granted, notice the hearing is published in the Federal Register, Section 556 and 557, Title 5, U.S. Code. Do not apply the hearings held under the subpart unless otherwise specified. The hearings under the subpart are informal with no advisory fact-finding proceeding at which there are no formal perceived adverse parties. Any regulation issued that indicate of the informal hearing is held with not necessarily based on exclusion of the record of the hearing. An administrator designates a representative to conduct any of the hearing held on the subpart. The chief of the council designates the member of his or her staff as the legal officer of the hearing. Alright, 193.29, adoption of final rules. Final rules proposed by the representative of the official with the pipeline safety, the official with the chief of the council regulations submitted to the administrator for the consideration. If the administrator adopts the regulation, if published with the Federal Register, and left all the persons subject to the name, then all persons served with a copy of it. 193.31, petition of the rulemaking interest of person may a petition the association administrator of the pipeline safety establish amendment of the repeal with a substantial regulation and may petition the chief of the council establish the amendment or repeal procedural regulations. Each petition filed under the second summary of the proposed action with explaining the purpose, state of the text of the proposed rule, with the amendment specified of the rule, with the repeal, with explaining with the petitioner interest of the proposed action, the interest of the aim of the part of petitioner represents. Provide information argumentative with the support of the proposed action, when they include the relevant technical, the scientific, other data available. The petition with the aim specific known with the code that is illustrated the need for the proposed action, potential impact with the proposed action, substantially information data related to the impact that are available. The petitioner, associated administrator, the chief of the council may request the petitioner with the conflict with the benefit of the society, with the identifiable group of the society, with the quantifiable with the otherwise. The direct effect of including the preemption of the effect of the proposed action state of the relationship between the federal government and the state of the distribution power of the responsibility among the various levels of the government, regulatory burden on the small business, the small organization, small governmental jurisdictions, recording the reporting of the requirements of the to whom they would apply the impacts of the quality of the natural and social activity environments. Associated administrator, the chief of the council may return the petition that does not comply with the requirements of the section accompanied by the written statement indicating the deficiency within the petition. 193.33, processing a petition. Generally, unless associated administrator, the chief of the council otherwise specified in the public hearing, argument for the other proceed that help directly with the petition before the disposition under this section. Alright, grants. If the associated administrator, the chief of the council determines that the petition contains adequate justification initiated with the rulemaking after the subpart of the denial of the associated administrator, the chief of the council determined the petition does not justify the rule of making the petition is notified denied. Notification of the associated administrator, the chief of the council will notify the petitioner with a written decision to grant a denied petition with the rulemaking. 193.35, petition for the reconsideration. Petition for reconsideration. Except to provide 193.39 D. The interested person with the petition with the associated administrator reconsideration and regulation and issue the under the subpart may provide petition. The chief of the council of the reconsideration and the procedural regulation issued under the subpart contained with the subpart of the petition must be received no later than 30 days after the publication rule with the Federal Register. The petition is filed at the time after a time will be considered the petition filed under 193.31. The petition must contain the brief statement of the complaint, examination as which compliance with the rules and practical unreasonable but not in public interest. If the petition requires the consideration additional fact, the petitioner must state the reason with why they are not presented by the associated administrator of the chief of the council with the prescribed time. The associated administrator of the chief of the council does not consider repetitions but petitions unless the associated administrator of the chief of the council otherwise provided the filing of the petition under the section does not state the effect of the rule. Alright, 193.37, the proceeding of the petition. The associated administrator of the chief of the council may grant the denial of the whole in any part of the reconsideration with further proceeding acceptable with the grant petition would result in the issuance of a new final rule. In the event of the associated administrator of the chief of the council determine the reconsideration regulation, the final decision of the reconsideration may be issued with further proceeding opportunity to smooth the comment, but the information tab the deemed appropriately may be provided with wherever the associated administrator of the chief of the council determine the position should be granted with the denial of the office of the chief of the grant. Chief of the council prepare with the note of the grant with the denial of the petition of the reconsideration if the due of the petition of the associated administrator of the chief of the council with the covenant issue of the petition of the associated administrator of the chief of the council may consolidate the petition relation to the same rules. It's policy associated administrator of the chief of the council the issue with the note for the action taken on with the petition reconsideration 90 days after the date which of the regulation question was published for the Federal Register unless it is found with impractical to take the action within that time and keep that was found with it beyond the period of the effective with a substantial notice of the fact of the day by which the expected action will be taken in the issue of the petition and published in the Federal Register. 193.38 appeals. And any interested person appealing with the denial of the associated administrator of the chief of the council issued on 193.33 and 193.37 the administrator of the appeal must be received within 20 days of the service of the note of the petitioner associated administrator of the chief of the council decision within 20 days of the date of publication of the decision. Federal Register should set forth a contested aspect of the decision, as well as any new arguments information left on administrator otherwise provided the following an appeal under this section does not state with the effectiveness of any of the rule. Alright, 193.39 direct final rule making. Practical administrative direct final rule making with the issue filing type of the rules minor substantive change with regulation and incorporation reference in the latest edition of technical industry standard extension of the compliance date of other non-controversial rule of the administrative determine the direct final rule with the public interest of the regulation it unlikely result of the diverse comment direct final rulemaking state with the effect of the direct final of the rulemaking also state that unless the diverse comment with no the intent of the file with the diverse comment that received within the specified comment period generally 60 days of that publication of the direct final rule the Federal Register Administrator will issue confirmation documentation generally within 15 days of the close of the comment with the period advised to the public of the direct final rule will either become effective on the date of stated within the direct final rule at least 30 days after the publication of the date of the confirmation document wherever it's later whichever is later. Alright, for the purpose of the section adverse which explain what the rule would be appropriate, inappropriately change with the rule without underlying the premise of the approach, or would be ineffective the acts unacceptable change with the comments with the privilege and insubstantial will not be considered an adverse under this procedure. Comment recommendation of the rule change with addition with the rule will not be considered an adverse comment unless the comments say that the rule would be ineffective without additional change. Only party of the file comment with the direct final rule will issue under this section may petition 193.35 for a reconsideration of the direct final rule. If an adverse comment with the note the intent of the final adverse comment with the receipt of the timely document will be published in the Federal Register advising the public in withdrawing direct final rule in whole with the part with the administrator may then incorporate with the adverse comment with the subsequent direct final rule with the may sub with the note of the published proposed the rulemaking the note of the proposed rulemaking will provide the opportunity for the public comment generally with a minimum of 60 days will be processed in accordance with the 193.11 through 329. Alright, 193.41, special permits. What is a special permit? What is a special permit? A special permit is ordered by the PHMSA waive the compliance with one or more of the federal pipeline safety regulation over the set forth in the Title 49 U.S. Standard Code 6118, subject condition with the set forth in the order of special permit is issued the pipeline operative with respect to operatives for specified facilities that are absent waive would be subject to regulation. How do I play with a special permit? The application for the special permits must be submitted at least 120 days before request the effective date using the following method. The direct fax for the PHMSA 202-3664-55-4566 mail express mail overnight with the courier associate administrator of the pipeline safety material hazard material safety administration 1200 New Jersey Avenue Southeast East Building Washington DC 20590. What information must be contained within the application? Application must contain the following information: name, mailing address, telephone number, application, whether the applicant is with a detailed description of the pipeline facility, which the special permit itself will include the beginning and ending point for the pipeline miles to be converted with the county of the states in which it's located, whether the pipeline is interstate or intrastate, and general description of the right of way, including the proximity of affected segments of the populated areas, usually sensitive areas. Alright, 3 relevant pipeline design and construction information, including the year of the installation of the material, the grade of the diameter, thickness of the coating type, and relevant operation information, including the operating compressor for the leakage, history of the most recent testing assessment visit. Assessment result. The list, specification, regulation, application, secret look at explanation unique with the circumstances of the application believed to make applicable regulation, standard with the portion of the unnecessary the appropriate with the facility, description any measure for the activity the applicant proposed the undertake with the alternative complying with the relevant regulation, including explanation of how such the measure they mitigate with the safety of the environmental risk, description any positive negative impacts affected with the stakeholder statement, including how the operating the pipeline pursuant with a special permit would be in public interest. The certification operation of the application of the pipeline owner with the requested special permit would not be inconsistent with public safety, pipeline safety. Any other information the PHMSA may need to process the application, including environmental analysis of the necessary. How does the PHMSA handle special permit application for the public notice upon the receipt of the application of the renewal with the special permit? The PHMSA provided the notice of the public in event with the consideration application event with the comment with additional PHMSA result with the federal agency before granting and denying with the application for the renewal of the matters. The PHMSA believe that they have significantly proceeded with under these areas responsibility, grant renewals and denial of the associated determine the application complied with the requirements of the section that waive the relevant regulation standard not inconsistent with the pipeline safety. The associated administrator may grant the application in whole or in part of the period of the time the date granted with the considered may be the input of the grant, but the associated administrator concludes that they are necessary to ensure the safety environment protection of otherwise in public interest. Associated administrator determine the application does not comply with the requirements section of the waiver is justified by the application denied. Whenever the associated administrator granted the denied the application, know that the decision will provide with the applicant. PHMSA PHMSA will post the special permit on the website of the phmsa.gov. How does the PHMSA handle special permit renewal of the grant? 1. The grantee of the special permit must apply with the renewal permit 180 days prior to the permit expiration. 2. If at least 100 days before the existing special permit expires, the holder of the file application of the renewal of the complete that conforms with the requirements of this section, the special permit will not expire with the final administrative action of the application of the renewal has been taken. Art 1. Direct fax of the PHMSA 202-366-455-66. Express mail overnight with the direct courier of the administrative of the pipeline safety hazard material safety administration 1200 New Jersey Avenue, Southeast, Washington, D.C. 20590. What information must be included with the renewal application? The renewal application must be included with a copy of the original special permit, the document number of the special permit, the following the information applicable, a summary report in accordance with the requirements of the original special permit, including the verification grantee's operation maintenance plan, and the OM is consistent with the condition of the special permit. Alright, your name, mailing address, the telephone number, the special permit, the grantee, location for the special permit, area of the pipeline where special permit is applicable, including diameter, milepost, colony, state. Applicable usage of the special permit, original fracture, feature of the data for the special permit in segments for the identified in special permits as needed, include the inspection include the pipe, attributed to the pipe diameter, thickness of the grade and seam time, this piping cone with the girth, weathering, welding, coating, operating pressure, minimum allowable operating pressure, class location, including boundary, aerial photograph, high consequence area of the boundaries are an aerial photograph, material property, pipeline material documentation of all the pipes and fittings, flanges, any other facility included the special permit material documentation must include yield strength, tensile strength, chemical composition, thickness, seam type, test pressures, hydrostatic pressure, data included the pressure, the temperature of the log, the known the failures of leaks, inline inspection summary of the inline inspection summary for revolve of the inline inspection tools used the special permit segments during the previous 5 years of latest inline inspection survey results. Integrity data integration. Following information application past 5 years for the hydrostatic pressure, including the known of the test failures, leaks, casings, any shore for the surface for the ruptured leaks, enclosed intervals, the surveys, depth of the cover survey, the rectifier readings, test point surveys, the earrings, alternate current directive, interference surveys, pipe coating surveys, pipe coating and anomaly evaluations of the pipe, excavation, stress, corrosion, cracking, selective steam, welding, corrosions, hard spot excavation findings, and pipe exposure encroachments, in service any surface of rupture with the leak, including the repair type of that failure, investigation, finding the aerial photograph, special permit segment, usually special permit inspection area. If applicable, the PHMSA may request additional operation integrity with the environmental assessment information prior to granting any request for a special permit renewal. The existing special permit will remain in effect with the PHMSA acts on the application for the renewal of the grant with the denied request. A special permit may be required for any emergency base for the PHMSA with the grant application for the emergency special permit without note that the comment hearing of the associate administrator determines that such the action of the permit public interest not inconsistent with pipeline safety is necessary to address the actual impending emergency involved in the pipeline transportation. For the purpose of this section of the emergency event, may be local, regional, national in scope, includes significant fuel supply with the disruption natural man-made disasters such as the hurricane floods, the earthquakes, terrorist acts, the biological outbreaks, the release of dangerous radioactive, or radiological, chemical, or biological material, war-related activities other than similar events. PHMSA will determine by case-to-case basis for the duration necessary to address the emergency. However, the required by the state true with no emergency for the special permit may be the issue of the period of time more than 60 days. An emergency special permit will actually expire with the date of the specified in the permit. Emergency special permits may be renewed upon application for the PHMSA only after the notice of the operating of the hearing on the renewal. How do I apply with the emergency special permit? Application for the emergency special permits may be submitted to the PHMSA using the following message with the direct fax of the Crisis Management Center 202-366-3768. Direct email with the PHMSA. PHMS Pipeline Emergency Special Permit.gov. Express mail overnight curve with the Associated Administrator of the Pipeline Safety and Pipeline Hazardous Material Safety Administration, 1200 New Jersey Avenue, Southeast Building, Washington, D.C. 20590. And what contained with the application of the emergency special permit. In addition to the information required on paragraph C of the section of application of the emergency special must include examine and explain the actual impending of the emergency of how the application is effect of the situation regulation implicated specific reason of the permit is necessary to address the emergency, lack of the accessibility, damage, equipment, insufficient manpower, or statement including how they operate in the pipeline pursuant to the emergency special permit in the public interest continuity of the service of the restoration, description of the proposed alternative to complying with the regulation, additional inspection, testing, shortened reassessment intervals. A description of any of the measure to be taken in the emergency of the situation permit expires whenever the company first the conform long-term operational reliable pipeline system pipeline facility. In what circumstances of the PHMSA revoke, suspend, modify the special permit, the PHMSA revoke, suspend, modify the special permit, and finally intervene with the change of the federal law mandating the record of revocation, suspension, modification of special permits, and made the material change with the conditions, circumstances, again, with the adherence to the terms of the special permit have been considered safety. The application containing the accurate but the incomplete information of the special permit would not have been granted with the application to have the accurate with the complete. The application containing the deliberately inaccurate with the incomplete information. The holder has failed to comply with any material term condition of the special permit except as provided in paragraph H3 of the section before the special permit is modified, suspended, or revoked. The PHMSA will notify the holder in writing of the proposed action. For these reasons, if word provided with the opportunity to showcase the proposed action should not be taken, holder may file a written response show that the proposed action should not be taken within 30 days of the receipt of the notice of the proposed action. After considering the holder the written response after 30 days of the path without response, then the request for the notice of the PHMSA will notify the holder in writing of the final decision brief statement of the reason and necessary to avoid risk segment with the harm and full person of the property environmental. PHMSA may in the notification declare the according to the immediate effect unless otherwise specified with the terms, the condition, the correction of the action, compliance order, and any other applicable pipeline facility covered in the special permit will take precedence over the terms of the special permit. The special permit holder may seek the reconsideration decision on paragraph H of this section, provided with the paragraph I of this section. Or K. Cannot deny request the special permit revocation of an existing special permit have been appealed. Reconsideration denial of the application of the special permit or revocation of the existing special permit that may be settled with the position associate administrator. Petition reconsideration must be received in the PHMSA within 20 calendar days. Note that the grant with the denial must contain with a brief of the statement of the issue with an explanation of the why with the petitioner believe that the decision being unplayable is not public interest. The associate administrator may grant the deny or on hold in any part of the petition reconsideration without further proceeding the associate administrative decision final administration action. Our documents related to the application of the special permit available to public inspection. Documents related to the application include the application itself available to public inspection regulation.gov, the dock operation facility, to the extent such document is not included, except for the public disclosure 5 of the United States Code. The application may request the confidential treatment under Part 7 in its title. AMI subject to the enforcement action not complying with the terms of the condition of special permit. The PHMSA inspect the compliance with the terms of the condition of special permit. If they have probable violation identified, the PHMSA will initiate one of the more than enforcement actions under the Subpart B of this part. Alright, 193.43. Information made available to the public request for the protection of the confidential commercial information. When you submit the information to the PHMSA during the rulemaking procedure as of your application for the special permit, the renewal for any of the other reasons you may make the information publicly available unless you ask that we keep the information confidential. Ask you for the protection of confidential commercial information. You ask them to give the confidential treatment of the information, give the agency to take the following step. More confidential on each page original document you would like to keep confidential. Send it along with the original document. Send a copy of the original document with the confidential commercial information. Please explain the information that you're submitting with the confidential commercial information. Your PHMSA decision. PHMSA will retrieve the confidential information you submitted in accordance with the section left to notify of the otherwise. PHMSA decides to go to the information. PHMSA will review the request to protect the confidential commercial information with critical set forth the Freedom of Information Act of Title 5 U.S. Code 552, including the following consultation procedures set out with the Department of Freedom of Information Act Regulation Title 49 CFR 7.29. If the PHMSA decides to disclose the information over the objections, you will notify the writing at least 5 business days before the intended disclosure date. Subpart E, cost recovery design reviews.